Okay, Abusuan latest update on former Chief Justice Gertrude Torkornoo and your project at the Ato screen no and chain at the among the former Chief Justice Gertrude Torkornoo seals government over withholding entitlement due her before the issuance of presidential warrant removing her from office. Abusuan latest update amameno at the abanono former Chief Justice Torkornoo a friend former Chief Justice Torkornoo sisi ano were seal a presidency. President Mahama or the nakwa kopie mu e court a o che say ne entitlement na eche say ya holding and as ye holding you know abusua ye di kan holding ne entitlement no before say ye ba be release warrant for ne removal nti ma me no o say onti ase o de akwa kopie mu e high court a abusua sisi ano maame Torkornoo asanso ade ne ho aba limelight na say ayisi ano wakwa kusiu president Mahama say ne entitlement na ye hodi entitlement before say ye dey no warrant no e ba be man say ye ba be removing it from office na busia we ne ensema breaking news aba ne ho nsem no so no empanfo ne bi e de nsem bi aba be tudwa lawyer ye friend no NDC lawyer ye friend no edozi tamaklu at the Honsem Biabato. Yamia corner, young conquetti and Sama Ecoso, but I must say.
The former Chief Justice is anchoring her reliefs on.
So you look at them and they've been serialized in this action that she has filed. And it starts by saying that the alleged findings and the grounds for recommendations of the committee set up by the president and Article 146.6 of the Constitution to inquire into and make recommendations in respect of the petitions for the removal of Madame Torkornoo as Chief Justice, chaired by Poaman JSC, do not meet, even remotely, the standard of stated misconduct, incompetence, or infirmity on grounds of inability to perform the functions of the office imposed by Article 146 of the Constitution. Again, she says, the findings and recommendations of the committee, that is Poaman's committee, blatantly violates relevant provisions of the 1992 Constitution and are therefore unconstitutional and illegal. Then she goes into the specific of the findings, talks about the first finding and says that the reasons for which using the committee found misconduct on the part of the Chief Justice for expenditure has not been disallowed against the CJ nor the CJ surcharge for it by the Auditor General. Then again talks about the first alleged finding and talks about how the committee's finding is one, misleading, irrational, unreasonable, and unfair. Then continues to say that the travel policy that has formed the basis of one of the grounds for her removal in terms of the finding of the committee, again, illogical, irrational, perverse, and absurd. So that has to do with the first finding regarding the issue of the Chief Justice traveling with their spouse and then the daughter and then paying them per diems. And then again, it goes on to say that the second finding and recommendation of the said committee constitutes an abuse of power given to the committee and is unfair, again, reasonable, unreasonable, perverse, and all of that, because the Chief Justice as head of the administration and supervision of the judiciary and judicial service with obligation, which includes transferring judges, including Superior Court justices, and judicial officers. It goes on. And then talks about the three alleged findings and recommendations for removing the Chief Justice from office by the Poaman Committee are false, misleading, irrational, absurd, and perverse in the Wednesbury sense. Getting close to some of these anchors on the ground, it says the entire findings and grounds of the said Poaman Committee are in violation of the applicant's constitutional rights contained in Article 19, 13, and 23 of the Constitution. And then a proceeding of the committee violated Articles 23, 296, 146.3, 146.7, and 295 of the Constitution are therefore illegal, void, and of no effect. And then finally, it says the entire proceedings of the said committee were conducted with substantive and fundamental procedures and unfair that renders the findings and recommendations nullity brace.
So those are the grounds on which she's basing this particular, action on. Now we know that she's also get all her entitlement.
Yes.
I mean, tell us more about that. You mentioned earlier, but
yes,
there's more
having
details.
been removed from office as Chief Justice, it would follow naturally that all her entitlements that was due her will be lost. For instance, if she retired as a Chief Justice, she would have been entitled to the salary of the Chief Justice until her death.
Okay.
And then there are other benefits, including and so if you look at some of the key reliefs she's seeking, she says she wants an order prohibiting the denial or withdrawal of the salary, 1, benefit, 2, courtesies, 3, and other entitlements, 4, that are due her before the warrant of removal that was dated the 1st of September 2025.
Now, we understand an action has already been undertaken. There's been an injunction application, and we don't know when this matter will come before a judge. Do you know anything about that?
So, if you look at this matter, and look at endorsement on it, to fix a date to be fixed, and court to be moved on, date to be fixed. So, there's not a specific date that has been filed with respect to this matter.
Okay.
When it comes to also an application for injunction, we expect that perhaps in the coming days, we don't know what strategy she and her lawyers will adopt. Perhaps they will file a substantive injunction application. We know that Parliament will resume next week, Tuesday. When they do, on that day, we have gotten information that the Council of State have advised the President to appoint Justice Bafuboni as the next Chief Justice. If that goes to Parliament, the Speaker will read that letter on Tuesday and then refer it to the Parliamentary Committee on Appointments. Then, in the next week or two, the Permanent Committee will vet Justice Bafuboni, who is currently acting Justice, and if he gets the approval of Parliament, sworn in by the President as Chief Justice. And so that means the Chief Justice may perhaps want to file a substantive injunction application and then get the court to hear it as early as possible prior to this, because in a line of cases, the courts have been very reluctant in terms of injuncting other arms of government from continuing some of those processes. But that is all up for the courts to decide if Madame Torkornoo files an action in the High Court.
Being joined on the line by Nia Ikoyotu, who is a former Attorney General and also a lead lawyer for the former Chief Justice before the Justice Permanent Committee. I'm grateful to you, sir, for joining us here. Now, we understand Parliament will be convening somewhere next week. If an injunction is not sought and Parliament carries through with the vetting of the new CJ, will this case still have a leg to stand on?
Well, okay. Thanks for having me. I think we have spoken sufficiently on this matter since the recommendations were made public, and then the President proceeded to act on it. I think the first judicial review was directed at finding out whether the President acted properly by removing and both a Justice of the Supreme Court and Justice of the Republic. What we have done this time is to attack the grounds which were used for removing her, and we're asking if we release. As to whether it's rule of law, at least when a case is sub judice, which means a matter is pending in court, we are all, in terms of respecting the separation of powers, not to interfere with the pendency of a matter which is before the courts, and a separate arm of government. So if the executive, both the executive and the legislature, want to respect the judicial arm, if they want to stay their hand while the case is pending.
But has the injunction application itself been filed?
Well, you will see that there is a prohibition order being fought in this particular matter which has been filed, not necessarily an injunction.
So you're expecting Parliament to, based on this, to probably stay till this matter is heard?
In a country of rule of law, the three arms of government are equal, and they want to respect the boundaries of authority exercised by each of them. And therefore, one would have thought that when a matter is pending, both the president and the legislature would want to restrain themselves and hold on and allow the court to determine the matter. After all, this is a judicial review application, and when the state file, the parties can rely on the statements of faith, and the judge can then rule without necessarily taking evidence, which will take a very long time. So I mean, if they want to respect the boundaries of authority, I don't think anything, prevents them from doing that.
But one of your reliefs earlier, the Supreme Court said clearly that it's difficult to injunct one arm of government. What still gives you that assurance that this relief you are seeking for could probably be granted?
This is a major and a substantive matter. It is not an interlocutory. You are rather introducing the interlocutory aspect. So it is that interlocutory aspect that will be problematic, if anything at all. But we have asked for a substantive order, not an interim order or interlocutory order.
But in this particular case, I mean, all the cases that, or the applications that the Chief Justice, the former Chief Justice, has filed, the court has had issues. I mean, they've dealt with them. They've not really granted all of them. What is the Chief Justice actually looking for to still be fighting this?
You've seen the release, so I'm surprised you're asking what he's looking for. What he's looking for are the grounds which are clearly stated that all the three grounds used in removing it are unreasonable, they are unfounded, they are not supported by the evidence on record, they are perverse. So, I mean, the grounds are well stated. So why are you asking me what is he looking for?
Because
you should know from reading it. And you had somebody who read everything to you before we came on to do this discussion.
I get it, yes.
Well, I'm sure you pretty well know.
Well, because, since this matter started, she has availed herself to the process. So someone will be asking, why avail yourself to the process and still challenge the process again at the end when the committee has come out with its findings?
Oh, thank you very much for asking that question. When you are given an opportunity to be heard, and you stand that opportunity, what do you think you have done? Are you then turning around to say that the committee was unfair or that the committee failed to give you a hearing? So once the committee is set up and you are invited to appear, it's only fair that you appear yourself. Now, the question that you could ask yourself is this: does it mean that once the committee comes out with a recommendation, those recommendations cannot be challenged in a country where we practice the rule of law? Do you understand what I'm saying?
Perfectly.
So if she is challenging the grounds that have been used to, remove her, why are you asking what she's looking for? She's saying that the grounds are perverse. They are unreasonable. They are not supported. I mean, how can a Chief Justice who is the head of a judiciary be told that if she transfers a worker, that amounts to a stated misbehavior? How can the committee come to the conclusion that when the Auditor General did not make any disallowance or surcharge against her, and she was not the spending officer, yet she should ultimately be held responsible for anything that had happened? I mean, you look at all the three grounds. How can you say that the Chief Justice, who is one of the constituencies for making recommendations for justice to be promoted or elevated to the Supreme Court, had made such a recommendation, and that amounts to stated misbehavior? So you look at the grounds that she's attacking and using to attack, and ask yourself whether there isn't much in what she's saying. There is everything for it, which any court in trying to do justice, you would be able and should be able to come to that conclusion that something horrible has happened, and that is the Chief Justice is entitled to the relief that she is seeking.
We've seen a Chief Justice that is trying to, some people have said, protect the institution she believes in. So if the court do not grant these reliefs, what is next for the CJ?
Well, we are already in the West African court, and they are giving a adjourned for some interim measures to be given before they were faced with this fear complete of the committee having, presented these recommendations, and the president had quickly and with an indecent, removed them. That is also still there, which is pending. There are other cases, the Supreme Court still do report that in one of the rulings, Akroma Amadou Tanko JSC, who gave that lead to Secretary, said that the substantive matter is pending, and that issue is for it. Some of the things is asking in the interlocutory injunction application would be taken care of. If you read the entire ruling, you'll find that. So that is also pending.
I'm grateful to you. Nia Ikwetu is a former Attorney General and a lead lawyer for the CJ during the Gabriel Palmer Committee hearings. Let's now bring in Godwin Edwiji Tamaklo. He's Director, Legal Directorate of the NDC. I'm grateful to you, sir, for joining here. Now, doesn't the former CJ have cause when she says one of the reasons that you've stood on to find misconduct in terms of expenditure? On that particular case, I have not that expenditure has not even been disallowed by the Auditor General, and therefore you cannot then use it as ground to remove me as a CJ.
Okay, so once again, good evening. Good evening to my learned senior, the Honorable Ayukwe. I think the preliminary matter that we need to first address. A committee set up Article 146. Is it after it has concluded its work to the remedies available in judicial review? I think it's the first question that we need to ask. Until we find an answer to that question, it becomes extremely difficult to proceed. Let me say this. The nature of the Article 146 committee and its work is sui generis. It is only known to the 1992 Constitution without more. Its workings and everything is supposed to be confined. So you notice that even the composition of that committee is dictated by the Constitution itself. Now, where the Constitution intends that the working, the findings of a committee should be subject to a further probe. The Constitution has always expressly made that clear. So, for instance,
sorry.
No, 1 minute.
Okay.
1 minute.
All right. Yeah.
1 minute. If you look at the Constitution, relative to, say, commissions of inquiry, it says a person dissatisfied with the work of that commission of inquiry has a right of appeal, which right the Constitution tells you where you can vindicate that right. the forum you can't go. Why were the framers of the Constitution silent? Because obviously they would envisage that not everybody will be pleased with the outcome of the workings of the commission set up under Article 146. And it's fine. You see, this is not like the commission is working and you are challenging maybe a decision taken in the... This is a commission that has concluded its work, submitted its findings, and based on those findings, the president has acted.
So is it lawyer, sorry, is it your argument that once their work has been completed, then one cannot challenge the decisions they've arrived at?
You see, when the Constitution wants to challenge an outcome of a body, it tells you where you can do. Where in this case, the committee has finished its work, submitted it, the president has acted on it. Like I gave you the example, the commissions of inquiry. Mm-hmm. So, for instance, I gave an example, Brazil commissions of inquiry, Ghana, all of those things. The Constitution says if you are not happy with this work, this is what you can do. How come that the framers of the Constitution were silent in an Article 146 committee? Now, the question and the challenge here is that, and that is, in order not to avoid a constitutional crisis, the framers left everything where it is. The president should act. The president has acted. Not only that, he had proceeded in making a fresh appointment. Then you come out with it. The question to ask is it the case that the framers of the 1992 Constitution, to avoid this, left the fact that no other thing flows from here? It ends. In the sense that, is this a disguised appeal closed as a judicial review? Remember that the committee under 146 and this working is supposed to be confidential. Now, if you permit a disguised appeal closed as a judicial review, the end result is to undermine that confidentiality, where in this case you permit somebody to put otherwise things that were supposed to be confidential in the public domain in the name of asserting a judicial review remedy.
All right. Lawyer, I'm grateful to you. Let me bring in Kwanzaa Sari now. He's former director, Ghana School of Law. I'm grateful to you for joining here. I want to understand, when the committee is done with its work, can't the person involved challenge it if he or she feels that there's been a wrongdoing somewhere?
No, not at all. So I agree with the last speaker. He, put, the matter right. You see, the framers of the Constitution didn't, create any window of opportunity, for a challenge. No such, route was created. So I agree with him. But the other question, can't we find, a way out? No. My answer is simple. A straightforward no. If in the wisdom of the framers of the Constitution, a challenge could have been entertained, they would have created another clause. So perhaps, we wouldn't have had 146. It would have continued in many more avenues. So, as far as the CJ removal process is concerned, the moment the president, acts in accordance with the Constitution upon the findings and recommendations of the committee, the case should, be considered closed.
But
for all intents and purposes.
Isn't that why we have the Supreme Court, such that if someone feels there is an unconstitutionality in the conclusion the committee has arrived at, then the law would have to be interpreted by the people who understand the law, not so?
Yeah, sure, but it is not in every case that the framers of the Constitution try to constitutional lawlessness or crisis in the country. So if you look at the modus operandi of Article 146, it begins with acknowledgement of a petition. So you read Article 125, clauses 1 and 2, in conjunction with Article 146, and you see that the framers of the Constitution aligned citizens' participation in the judicial process in initiating petitions for the removal, of the Chief Justice. In the case of the President, you see a different process. So let us restrict ourselves, to Article 146.
Okay.
I am submitting that nowhere in Article 146 is there room, to challenge the final decision. So once the President makes, a decision on the findings and recommendations of, any such committee, we have come to the end of the road. So no one, can open the President. Under the Constitution, the key is not, left hanging on top of the door. No, it's being taken away, and therefore there is no key with which to open and enter.
Okay.
That is the position of the law.
So based on the premise you've built, there's much ado about nothing in this particular case.
Apologies to Shakespeare.
Grateful to you, sir, for your time here. Kwanzaa Asare is former director, Ghana School of Law. And that's how we conclude the story for you. Brought to you.
Okay, abusua we ne ensema ekoso ewo political highway so former Chief Justice Torkornoo ye can be breaking who news de amamo ayisi ano or say onti ase committee a ye de eba be vet acting Chief Justice Bafuboni no ho nsem ne guso ebo ba sisi awasa nso akwa pimu ewo court a wasiu presidency we ne ensema ekoso ebe da moje pene kokoti sa ensem we e de ban ha Ghana Politics Avenue so bedamase.